Good morning. This is the New York City Board of Standards and Appeals special September 20th, 2017 appeals calendar. The first and only item is 2016 4327A, 15 East 30th Street, Manhattan.
Is the appellant's rep here?
Good morning, Chair Perlmutter and members of the board. My name is Karen Mira. I'm an attorney at Carter, Ledyard & Milburn, representing the appellants. As you know, my colleague, Chris Rizzo, has been representing the appellants since the initiation of this appeal. He is unable to be here today because, as some of you know, his newborn twins arrived early in California on September 14th, and so he is there in California with them. They are hospitalized for several days after the birth, and he would have liked to be here to answer your questions, but obviously he is otherwise occupied. However, Mr. James is here. I want to note for the record that he did request an adjournment. That was denied. However, if there's any follow-up issues that you would like Mr. Rizzo specifically to address, he would be happy to respond in whatever form you choose. And with that, I will turn it over to Mr. James, who is also very well-versed on all the issues that the appellants have been discussing before.
Good morning. My name is George James. I'm a planner. I'm not an attorney, but I've been working on this with the condominium since 2016. I was here on Monday. I heard your comments. I prepared some materials to address some of your questions. But let me start by addressing the issue of the Chandler's C of O, because clearly there was a misunderstanding. I did not and do not believe that simply stating the facts as we understand them is a challenge to the C of O of the Chandler. At the July hearing, we did not understand that the BSA had concluded that the restatement of our facts was a de facto challenge to the Chandler C of O. For the record, we have not challenged the Chandler C of O and do not believe the restatement of facts is a challenge. Instead of informing Chris Rizzo of your interpretation, the BSA proactively contacted the Chandler so that they could engage counsel and come to the hearing.
Incorrect. We never contacted the Chandler. No, sorry, incorrect.
Okay, thank you for that.
We advised the appellant that because this appeared to be a challenge to the Chandler, that the appellant needed to notify the Chandler because they become effectively an involved party in the case.
Thank you. That was unclear how the Chandler found out. Clearly, we weren't informed that they would be an involved party in the case, and it was confusing.
When you say we, who's the
we? Meaning Chris Rizzo, the
No,
attorney.
sorry, we contacted Chris Rizzo and said you need to notify the Chandler because they're an involved party. If he didn't understand why he was being asked to do that, it's a different thing, but that's who notifies. No, the BSA does not give notice.
Right.
Okay.
I was shocked by that.
Okay, so BSA doesn't give notice. Yep. We ask the applicant, in this case it's an appellant, always gives the notice. So the notice went out from Mr. Rizzo's office, okay?
Okay, thank you for that.
Okay.
That I've had several conversations with Chris, and he did not actually inform me of that. And I don't think he actually knew. But maybe, but thank you. The facts remain the facts, though. And the facts are that there are residences in the Chandler. The hotel, while there are residences in the Chandler, the hotel is primarily used for transient occupancy, and so meets the zoning resolution of a definition of a commercial transient hotel. There is evidence, however, that at least one, and possibly more, of the legal permanent residents of the Chandler will have their access to legal light and air impacted by the proposed building because their windows will not face a legal court. Now, the space on the east side of the Chandler, formed by the Chandler and the new building proposed on the zoning lot, is a court. The July hearing, the space was discussed and it was described as a side yard. The space can't be a side yard, right? It's in the middle of an enormous through lot. There are no side lot lines. You have to have a side yard, you need to have a side lot line. The only way that this court could be interpreted as a side yard is to assume that the tax lot lines or the former zoning lot lines created a side yard, which you can do, right? It's called former lot line theory. To quote the DOB, former lot line theory is a zoning concept not defined in the New York City zoning resolution, but which is historically acknowledged and granted by the department. If the BSA wants to accept former lot line theory, a DOB interpretation with no basis in law, I see it's discussed in our papers.
But it's never been discussed, so I don't really want
Yeah.
to do this all over again, but so
Yeah.
the rule about appeals, interpretive appeals, is the Department of Buildings has to be, the specific question that you want the Board of Standards and Appeals to consider must be asked of the Department of Buildings, and the Department of Buildings then opine on that and issue a final determination. Absent that, the board can't consider it. So we've never been presented with the Buildings Department's final determination on the former lot line theory. So if it's mentioned in papers, we don't have the authority to review it until the Department of Buildings has an opportunity to consider fully what it means by that and so on. And then the board looks at whether the Department of Buildings misinterpreted the zoning or interpreted correctly. Okay,
Okay,
so it's not a question before us. That's why I'm
Okay. And I
quizzical,
accept that,
because I don't know.
For the record, we have to say former lot line theory exists. It was applied at the hearing to describe a space, and it is something that the DOB uses, and they've said that they use. Which is acknowledged not to be a concept in the New York City zoning resolution, but acknowledged and granted by the department. And similarly, the DOB has stated that the entire mechanical floors are exempt from floor area, when the zoning resolution merely exempts mechanical spaces. The DOB has interpreted spaces to mean floors. You may agree with that determination or not. It's your right, but make no mistake, it's an interpretation, it's not zoning text. So, with this said, none of us can say with a straight face that because the text of the zoning resolution doesn't qualify that accessory mechanical spaces need to be reasonable or need to be necessary or proportionate to their appropriate purpose, that we shouldn't expect the DOB to place a reasonable test on these spaces. In fact, I know that the DOB has challenged mechanical deductions as being excessive in the past, and it's fair to ask if they've used a test of reasonableness for the mechanical deductions claimed here, and if not, why not? Now, I acknowledge the BSA's concern over our lack of finding a mechanical engineer willing to comment on the record regarding the reasonableness of these spaces. I tried. I really did try. I could not find somebody with the experience, somebody who's built these buildings, qualified and willing to testify on the record in front of you. It's an acknowledged weakness in our argument. But the fact that we could not find a so qualified engineer to state their opinion does not mean that these spaces are reasonable. Now, you stated on Monday that presumably DOB mechanical engineers have reviewed these plans. Have you asked the DOB about which mechanical engineer reviewed the plans and what they had to say about them? Were they reviewed for just building code compliance? Were these reviewed for zoning compliance? I understand that this proactive questioning may be outside of the normal way of doing business, but they're open questions. Perhaps the chair does not want to presume that a qualified mechanical engineer examined the drawings, but you might want to know more about the examination, the conclusions, considering the size and location of the space, or not. It's your prerogative. Finally, you've stated clearly your thinking on this matter, and I appreciate that. So instead of continuing to argue the specific issue, I want to conclude with a more general statement on the use and construction of these spaces. Large mechanical voids, such as those found here, are not unique to this building. They can be found in dozens of buildings currently planned, under construction, or recently built. New technologies that make building tall less expensive, a market that supports the high costs of very tall buildings, combined with the ability to use unlimited mechanical exemptions as platforms to achieve height, are combining together to effectively change our bulk regulations in tower districts. For instance, another building under construction on 57th Street has 390 feet of vertical feet of mechanical floors. It's 27% of the building is devoted to accessory mechanical spaces and voids. This change of previously understood construction limitations and development paradigms is not rooted in public policy or apparently regulated in any way. It's just happening. One way to address this issue is for the city to find a legislative solution, clearly. Another way to address this issue is for the DOB to exercise its discretion, as it often does, to add a reasonable test or a necessary test to mechanical spaces. I hope that when you render your decision on this matter, that you make your thoughts known on this larger issue facing New York. Thank you.
Okay, thank you very much. Department of Buildings?
Good morning, Chair Perlmutter and Commissioners. My name is Mark Davis. I represent the New York City Department of Buildings. The department attended the executive session and has heard all the testimony in this matter to this point, and we don't believe that the latest submissions by the appellant have added anything new to this matter, and so we are prepared to rest upon our submissions unless the commissioners have any other questions.
No, I don't think so. Does anyone? No. Okay, thank you.
Commissioners.
Are there any speakers on this? Yes, please come.
Good morning. My name is Franny Eberhardt, and I'm president of the Friends of the Upper East Side Historic Districts, an organization that is dedicated to preserving the architectural legacy, livability, and sense of place of our neighborhood. We're a 35-year-old community-based organization, and obviously this building that you're discussing this morning is not in our neighborhood. But as Mr. James suggested, the decisions made here today and the buildings either being built right now or being planned do affect other neighborhoods. This phenomenon of the excess mechanical spaces is spreading. And it's arrived on the Upper East Side at 180 East 88th Street, where a mere 30 feet, roughly 10 stories, is empty in a building, hiking it way above what is normal for our neighborhood. The techniques employed here at 15 East 30th are becoming, therefore, the new normal for developments catering to a luxury market and effectively changing the way bulk regulations are interpreted. But policy has not kept up. Regardless of your decision today, the BSA's decision, Friends urges the agency in its findings to charge the Department of City Planning and the Department of Buildings to work together to address improperly exempt interior mechanical spaces. It's a citywide issue that's becoming more relevant with every proposal that we see that exploits these loopholes. If the market is such that developers are motivated to construct empty voids to act as stilts, these voids need to count, at least in part, towards their FAR. The zoning resolution really needs to be amended to address these techniques and thereby affirm the noble purpose for which it was originally written in 1961. Thank you.
Thank you very much. Next speaker, please.
Good morning. My name is Marcel Negret. I'm a project manager at the Municipal Art Society of New York. MES believes that the DOB's determination regarding the compliance of the proposed tower with the New York City zoning resolution is incorrect, or at least open to interpretation. MAS recommends that the Board of Standards and Appeals rule that the zoning resolution has been inadequately interpreted and the building permit is invalid. As part of the building permit in question, the developers requested to construct 5 mechanical floors comprising over 100 feet in height, which would result in approximately 23% of the total tower's volume dedicated for accessory mechanicals. We also I'll be submitting these testimonies, we have two figures showing that visualization. The zoning resolution is clear in that enclosed spaces should count as floor area with the exception of certain uses, including mechanical space. However, the applicants describe these areas as a structural void, which incidentally holds limited amounts of mechanical equipment that is not proportional to the size of the space. We question what type of mechanicals demand such a staggering amount of volume. This practice, as it's been stated earlier in the previous testimonies, is a relatively new phenomenon. Many new towers disguise these voids as accessory building mechanicals, incorporate them to solely increase their heights, views, and prices. As was mentioned by George, the also known tower as Non-Strom Tower, located at 2017 57th Street, uses at least 350, perhaps more, of its height dedicated to a structural void. We've been monitoring over 100 buildings that are being planned, under construction, and trying to recreate them with the open platforms that are available to us. And even in comparison to these skyscrapers and super talls, this particular building has a substantially much more dedicated use and height to structural voids. And finally, just wanted to conclude that the issue of regulating the use of structural voids in building applications is not necessarily a new one. We're not referring to a new one. This was discussed over 20 years ago, in which a 1999 study issued by the Department of City Planning, which included numerous recommendations on how the zoning resolution could be reformed to better regulate bulk, identified deductions of mechanical space from zoning floor area by developers as contributing factor to out-of-scale development. At the time, the biggest case study or issue of development that was reflecting this was the Trump World Tower nearby the United Nations. At the time, the city had recommended that in high-density districts, a 10% allowance of floor area for mechanical space should be put in place. 10% allowance of floor area for mechanical space should be put in place. We recommend the BSA take the lead in examining this issue and coordinate with the City Planning Commission to determine appropriate heights and floors for mechanical spaces in building permit applications. Perhaps a renewal of such a study will be appropriate. Thank you very much.
Thank you very much. Next speaker, please.
Hi, I'm Harry Bowens with Greenwich Village Society for Historic Preservation. I've also submitted the Landmark West written testimony as well, also supporting the revoking of the permits. We still have serious concerns about the appropriateness of the permits granted by the Department of Buildings for 15 East 30th Street. In the executive session Monday, the chair noted that, quote, "No one is disputing that a structural void is a use." At issue then, in this case, is the question of whether or not excessive amounts of space can be deemed mechanical space, even when the space has been described as a structural void by the applicant. The chair faulted the appellant for not having an engineering report evaluating the space. But the Department of Buildings has not provided a rationale for their evaluation that this unusually generous amount of void space is necessary or fits within the zoning definition, saying such matters are reviewed only on a case-by-case basis and therefore has not provided any basis for refuting or counter-analyzing their claim. Instead, we believe the board has the ability and obligation to conduct this analysis itself. New York City Charter Chapter 27, Section 659, Part B, says in part that regarding the BSA, quote, "One of the members shall be a licensed professional engineer and shall have had at least 10 years' experience as an engineer." The purpose of requiring a BSA member be an engineer, as stated in Rules and Practice and Procedures, New York City Board of Standards and Appeals, Section 1-01.8 is, quote, "The board may derive its authority from additional legal and regulatory sources not described above, but contemplated by its general charter authority. The need to verify or dispute a nexus between such an inordinate amount of space assigned for mechanical use in the face of such serious question is well within your general authority." At the last hearing, the Department of Buildings did not explicitly indicate how or why so many numerous floors of mechanical space is appropriate. They have failed to make a specific determination of how many feet would be allowed. Can it be 50 feet per floor, 100 feet or more? Would the commissioners require an engineering report to refute a need for 200-foot high mechanical space per floor for a similar residence? Cheating the FAR count and making a mockery of the 12 FAR limit for residential use imposed by New York State law are not the only harms which can be done by this practice. An additional argument we believe is found in Article 10, Section 104-60 of the zoning resolution, which pertains to modification of special bulk requirements and transfer of floor area by special permit in a special district. And I know this is not in a special district. But that creates a process to modify requirements, provided that they are needed, quote, to meet programmatic and mechanical requirements. This presupposes that the amount of space assigned in a building has an understood relationship to need, but such need has been challenged here with no evidence by the DOB to back up their evaluation. Finally, in regards to the powers of the Commissioner of the DOB, New York City Charter Section 645B2 notes in part, quote, he, and it says he may permit the use of such materials or of such forms of construction, I'm almost finished, provided that the spirit of the law shall be observed, safety secured, and substantial justice done. Allowing such an unjustifiable spatial void would most certainly violate the spirit of FAR limits and not do any justice. On these bases, among others, we believe the permit should be revoked.
Thank you. Next speaker, please.
My name is Lo Vandervalk. I'm president of Carnegie Hill Neighbors on the Upper East Side. We see this example of 15 East 30th Street as just one example of a larger trend. We are experiencing in one case, a very similar situation, maybe not as bad as the current case, at 180 East 88th Street, where a very tall building is going up. And although we are trying to engage the Department of Buildings in trying to make certain changes, but it's been very difficult. Obviously, throughout the city, there are countless other examples. We urge the BSA to make some note of this in its decision, so that it can point to this larger issue, even in its findings that are generally specific to the case in question. This is a larger, broader finding that we hope you will be able to incorporate. Clearly, we need to have other ways of counting mechanical spaces and voids as FAR, or to limit them in other ways. So obviously this is the beginning of a, we're in the early stages of reconsideration. Clearly the Department of City Planning needs to be involved, and new regulations need to be introduced in the zoning resolution. That's our feeling. Thank you.
Thank you. Okay. Other speakers?
Good morning, Madam Chair, members of the board. My name is Jesse Mazer. I am counsel to 15 East 30th Street. Very brief. One, we'd like to state our appreciation for the exhaustive review done by the board and its staff, and we would urge your vote today on this matter. Thank you.
Thank you. Any other speakers? Just for the record, with respect to the notice to the Chandler Hotel, I do have the access to the file here. On May 23rd, 2017, Carter Ledyard sent a letter to the board advising us that notice, let's say, advising us of the delivery of Federal Express to certain parties, which included the property owner of the subject property, various officials, including DOB, and notably, with respect to this question, Le Marquis Associates LLC. And it says the submission from February 6, 2017 was also served on Le Marquis Associates per the BSA's request. Le Marquis is the owner of the Chandler Hotel. Okay. And just one comment about mechanical engineers. The board does not have on its staff a mechanical engineer. It traditionally always has a structural geotechnical engineer on its, as one of its commissioners, because that is actually the subject that comes up most often before the board. And so we often rely on the Department of Buildings, who has mechanical engineers, to review the mechanical questions. And in a situation where the amount of mechanical space is being questioned, we rely on the appellant to bring in a mechanical engineer. Otherwise, we're looking at drawings that show, and I can read mechanical drawings, though I can't analyze whether all the equipment needs to be there, but we're looking at drawings that are prepared by mechanical engineers that show the floor space absolutely filled with mechanical systems. And by comparison, just to see if we could make sense of those floors, we looked around at other towers that are under construction, and nearly every one of the ones that are under construction in the last, say, 5-10 years has these interstitial mechanical floors that are approximately the same height. You don't actually have to go far. You just look down the street, and there's a building that was finished last year that has exactly 4 interstitial mechanical floors. There, they happen to be spread throughout the building, but it seems, and as is 432 Park, so it seems logical to assume that that's sort of a standard method of dealing with the mechanical issues that confront tall towers. And then, just to reiterate, because we've already talked about it, and yesterday, just for people's information, yesterday there was a review session where each of the board members expresses their, Monday, where each board member expresses their opinion about the case, and that's available on YouTube, access through our website, so you can actually hear our reasoning. But the critical points here are that the board is asked to look at what does the zoning resolution say, and not at the sort of the broader whether the City Planning Commission did the right thing. And the zoning resolution with respect to mechanical space gives no instructions at all about the verticality of it, the cubic, the volume of it, nor does a use ever get defined in terms of volume. Sometimes uses are limited by square feet, but not by volume. So we don't have anything in the zoning resolution to even say is, sometimes we'll say something in the zoning resolution is ambiguous. Then we can go look behind and say, let's go look at legislative history. What did the City Planning Commission mean by that? But here there's absolutely no ambiguity. There's no mention anywhere of volume or height in the definition of use or in the definition of mechanical space. So we don't have anything to hang our hats on that would allow us to decide that a mechanical floor is X big and X tall. And I go back to something that I said earlier, which is if I wanted to build a building with 40-foot high ceilings per apartment, because that's all the rage, it could be done because there's no limit on floor area in terms of height. And ditto for a ballroom. Used to be all the rage that ballrooms had 80-foot ceilings. So you could just, in a hotel, stack 2 80-foot high ballrooms on top of each other, and you'd be in the same place. And people might argue, oh, but a ballroom should have an 80-foot high ceiling. So again, because there isn't any limitation on use, it's more, at the moment, it's the creativity of the architect and developer in terms of how high, it seems to me. And this really is something that should be brought up to the City Planning Commission, and legislation is where it needs to be placed, and we're not legislators here. Anybody else want to comment? No? No. Okay. So with that, I would like to close this hearing.
Chair Perlmutter,
Aye.
Vice Chair Chanda,
Aye.
Commissioner Ollie Brown.
Aye. And I'd like to bring this to a vote. So the question is a motion to grant the appellant's appeal is how we phrase it. So a motion to grant the appellant's appeal.
Chair Perlmutter,
No.
Vice Chair Chanda,
No.
Commissioner Ollie Brown.
No. Thank you very much. Thank you all for coming.
This concludes the September 20th, 2017 special hearing of the New York City Board of Standards and Appeals.